All right. Welcome everybody to the Canadian IP Litigation 2024 a year in review webinar. Bonjour à tous. We'll get started with some introductions as attendees are still joining, since we have a lot to discuss and talk about today. First, I'm joined today by our senior associate, Matt Burt, based in Ottawa. Matt is involved in all sorts of IP litigation, including more recently a number of high-stake pharma matters. I'm also joined today by our principal, Daniel Davies. Dan is also based in our Ottawa office and is one of our senior litigators. He's been also involved in all sorts of IP matters before the Federal Court of Appeal, and Supreme Court. In fact, Daniel and I had the pleasure of spending most of December in Toronto last December doing a patent trial with some of our other colleagues. Lastly, I'm also principal based in our Montreal office, and I have the privilege of leading our very active litigation practice, and I'll be your moderator for today. I'll note that if you haven't seen it already, Matt and Dan prepared a very instructive year in review article that has been published on our website that will serve as a basis for our presentation today, but will also cover other topics briefly that were not didn't make the cut to in terms of the article. I'll also note that we've published a trademark, a patent, and a pharma-specific year in review articles that do discuss a number of decisions from 2024. We tried to avoid having too much overlap between the articles and the webinars, but if you're interested either in patents or trademarks decision or specifically pharma decisions, I invite you after the webinar to go on our website and have a look at those. Lastly, we'll invite you to ask questions as they come up. You can use the Q&A function in Zoom. Nobody will see that you're asking questions, so don't be shy. I'll either ask them to our two panelists as we go along, or towards the end, we'll try to keep 10-15 minutes for questions. So again, don't hesitate to ask your questions. Vous pouvez aussi poser vos questions en français si vous le préférez. And with that, I'll end it to my colleagues and come back later with questions.
Thank you, Jean-Sébastien. Can we get an injunction? And if so, when? Those are often some of the first questions clients have when thinking about an IP lawsuit. So the first topic we're going to address today is what happened in 2024 on both of those fronts. So an injunction is one of the main goals that litigants are trying to achieve in infringement lawsuits. It's an order from the court that stops the infringer from continuing to infringe. A permanent injunction is typically the name we give to the type of injunction that you get at the end of trial. So if the patentee or trademark holder is successful at trial, then what they would get or may get is a permanent injunction that prohibits the infringing activity for the remaining life of the intellectual property in issue. And that's in contrast to pretrial injunctions, which I will also touch on. Now, historically, the answer to the question, can we get an injunction, was almost certainly. Permanent injunctions generally are a matter of course in Canada if you are a successful patent or trademark holder. Of course, there is always discretion. It is an equitable remedy, so the court is not bound to order an injunction, even if you are to win your infringement lawsuit. However, in almost all cases, they were granted. And injunctions are considered a fundamental way of protecting an exclusive right. If the law provides you the exclusive right to do something, then you should be able to force others to stop. But in the last couple of years, there were a couple of cases that raised some eyebrows about just how matter of course or routine injunctions are. And one of those cases is the Davies and Jean case that's referenced here. That was a pharmaceutical case relating to Humira, which was patented by AbbVie, and the court found in that case that the JAMP product infringed AbbVie's patent. However, in that case, the court declined to grant an injunction. And at least one academic has noted in an article that that appeared to be the first case since 1993 where a court has found that there is an infringement of a valid patent, but yet declined to grant an injunction. So a question that was on people's minds in the IP bar was, well, is this just a one-off case, a unique situation, or is it the beginning of a new trend? Now, the court in the JAMP case did acknowledge that it will be a rare case where an injunction is not granted to a successful patentee. But the court did find that in the circumstances of that case, it would not grant an injunction. And the reason that the court provided was that it would be against the public interest to grant an injunction. Essentially, patients who were using the JAMP product would be sufficiently harmed by having it pulled off the market that the injunction should not be granted, given all the circumstances. So essentially, some of the things that the court cited were essentially the different formulation of the JAMP product. It was formulated in a way that it may have been less painful at the injection site for some patients. The court even referred to evidence of a possible nocebo effect. Essentially, patients who switched from the JAMP product to one of the competitors could be tricked by their psychology into thinking that they have more pain at the injection site. And the court actually finds in that case that the risk to the patients was low. But nevertheless, the court still considered that it outweighed the benefits of an injunction and declined to grant it. So there was at least some uncertainty. Is the answer to, can we get an injunction, still almost certainly, or has the answer now changed to, well, probably? And adding to that uncertainty, JAMP actually came on the heels of another 2022 decision, which casts another shadow of doubt about the extent to which patentees can rely on getting injunctive relief. And that is the 2022 decision of the federal court in Roe v. and Bell. Now, in that case, the court was addressing remedies in the hypothetical. It had already found the patent claims to be invalid and was simply commenting on what remedies it would have granted had it found the patent to be valid and infringed. For example, in case the appeal court found differently on the issues of validity and infringement. And in that case, the court found that even if the patents had been valid and infringed, the patentee should not have been entitled to an accounting of profits, first of all, but also a permanent injunction. And some of the main considerations that the federal court used in arriving at that conclusion were, first, that the plaintiff was a non-practicing entity. Essentially, it licensed its patents instead of selling a competing service. And in that context, the court did not think it should deprive millions of customers of the IPTV products or services in issue and force Bell and Telus to have to modify their services, even though there wasn't that much time left on the patent. The court was also concerned about what it considered to be delays in the prosecution. It cited the length of time that the patentee took to request examination of the patent application, which many people actually considered normal. It's not uncommon to wait the full 5 years that you're allowed. But the court was concerned in this case about what it referred to as the patent holdup problem. And the patent holdup problem is essentially that an injunction can become much more damaging to the party subject to it once that party has also already invested and launched a product that is now alleged to infringe. So it having made that investment, it would now be much more difficult to change than it would have been, for example, at the beginning. And the patentee can therefore, by getting an injunction, can hold them up, essentially extracting a higher licensing fee than might otherwise be justified because it'll cost the defendant so much to change course. So again, perhaps in this case, there were some fact-specific elements at play, but the question was raised, are injunctions still matter of course, or are there now an increasing number of categories of cases where they might be denied despite the patentee being successful? And so in 2024, we actually got an appeal decision in the Roe v. matter. And this decision was again addressing remedies in the hypothetical, but the federal court nevertheless commented on injunctive relief and essentially put us back where most people thought we were before the Roe v. case and the JAMP case came out, that an injunction will generally be granted unless there are exceptional reasons why not. The court specifically commented on the justifications that the federal court had in the trial decision for why it wouldn't have granted it. The court said it doesn't matter if the patent is close to expiry. Injunctions still should be the default. The court also commented on the fact that a patentee that chooses to commercialize its patents by licensing them shouldn't be necessarily deprived of injunctive relief. So being a non-practicing entity is not going to be a determinative. And the Court of Appeal also disagreed with the federal court's reliance on delayed patent prosecution as being a factor in denying injunctive relief. So I think for patent holders, 2024 was an encouraging year in terms of the strength of the remedies that you could get upon success in a patent infringement matter. There was also, moving on to the trademark context, some case law on pretrial injunctions. So these are injunctions that are issued near the beginning of a lawsuit that define the party's rights while the lawsuit is ongoing. And the theory of those is that in some cases, if you have to wait months or maybe a couple of years before trial in order to get the infringer to stop the infringing activities, then there may be harm that can't be compensated for with damages. Essentially, the plaintiff might lose something it can't ever get back. In some cases, that might be because the defendant won't be able to pay any damages. And in other cases, it's the nature of the harm itself is something that money can't fix. And in the trademark context, pretrial injunctions have become a strong remedy in the last number of years. There are cases where a company's goodwill and the distinctiveness of their trademark have been essentially the basis for the grant of pretrial injunctions on the theory that these are really things that once ruined can't necessarily be fixed by payment of money at the end of the day. And I think the takeaway from this is that really the very types of rights that a trademark lawsuit may be brought to protect, the very types of rights that trademark law is meant to protect, can by themselves sometimes be sufficient to entitle one to a pretrial injunction. And we provided some slides on the Arc'teryx case from the British Columbia courts in 2024 as a good example. This was discussed in detail in our trademarks year in review, so I won't repeat it, but the ultimate point is that pretrial injunctions are becoming quite a strong remedy in trademark cases simply to protect things like distinctiveness, goodwill, and avoidance of customer confusion. So with that, I will go on to another topic on the theme of strong remedies, namely site blocking orders. So site blocking orders are a recent innovation in the area of enforcement of copyright against piracy. A typical injunction of the type we just discussed, it would order the wrongdoer to stop what they're doing. But what happens if you're dealing with people or entities who don't really care what the court has to say, and they're hard to find and catch? Well, that's where site blocking orders come into play. Essentially, it's an order that the internet service providers, so for example, people get their internet services from Bell or Rogers or a number of other providers, and the court is ordering those providers to block certain websites from their customers. So because of that block, all the customers of those providers who are subject to the order wouldn't be able to access those sites. It prevents them from being able to, for example, watch a pirated stream of a sports event. And now another problem that arises when dealing with piracy is that these streaming sites essentially move faster than the legal system can move. And live events provide specifically unique challenges because the blocking would only matter during the event. It doesn't help if you get an injunction for last weekend's game when the Pirates are now illegally streaming this weekend's game. And there's also inefficiencies in having to do each league separately and do each site separately. It doesn't help if you get an injunction for the IP address that the pirate was using last week when this week they're using a different one. So all of these considerations are now being taken into account in a 2024 decision where we now have an order obtained by some of my colleagues in Montreal where it applies to multiple leagues, all in the same order. It allows for real-time blocking as the infringing streams are identified. So the rights holder would identify that there's an illegal stream, for example, during NHL game or an NBA game, they would notify the internet service providers who would block those sites from their customers as they pop up. So that you can't get around it by just changing exactly the name of the site. It also applies to future content, so you don't have to go back to court for every different event. And it goes on for 2 years, where essentially all the events from these leagues can be blocked on an ongoing basis as the infringing websites pop up. Now, the court is still being careful here, building in protections to make sure that these orders aren't abused. But overall, this is a positive development in moving towards practical and cost-effective combating of piracy. I believe the next topic I will turn over to Mr. Burt.
Thanks, Dan. Yeah, so the next topic that we will discuss is quite a bit different, and it relates to the ground of patent invalidity known as ambiguity. And this was the central issue in the 2024 patent case involving Tecna and AP&C, in which the trial judge held that almost all of the claims of the patents in issue were invalid for being ambiguous. And I think this case is noteworthy because it is quite rare that a patent claim will be found to be ambiguous, and even more rare that this ground of invalidity is dispositive of essentially the entire case. And so just to give a brief background on the parties and the action. So this case, as I said, involved Tecna and AP&C, which are two Canadian-based companies that produce metal powders. And these metal powders have applications in additive manufacturing, which is sometimes referred to as 3D printing. And so the patents at issue in this case, there were two that ultimately made it to trial. They related to the production of metal powders. And this was an impeachment action. So Tecna commenced the action seeking to invalidate AP&C's patents. And then unsurprisingly, AP&C counterclaimed for infringement. And so as I mentioned earlier, the central issue in this case was patent claim ambiguity. And the trial judge, Justice McAfee, acknowledged throughout his decision that there is a general disinclination for finding patent claims to be invalid on the basis that they are ambiguous. The court will in all cases endeavor to give meaning to the claims, which are presumed to be valid. And so just because a claim term or a claim is challenging to interpret, this doesn't mean that it's ambiguous. Just because a claim term may be open to multiple interpretations, this also doesn't necessarily mean that it's ambiguous. And in fact, in most patent cases, the trial judge will be faced with competing interpretations of certain claim terms presented by the parties opposing experts. But having said that, clarity in the claim terms is important. It serves a very important function. And there's actually an explicit requirement in the Patent Act, which requires that claims define distinctly and in explicit terms the subject matter of the invention, because it is the claims that let others in the relevant industry know, or the public at large, what they can and cannot do, whether their activities are infringing or not. And so the test for assessing claim ambiguity, I think, tries to strike a balance between having the claim serve this notice function while also acknowledging the pitfalls of language. And the test or the question that is asked in cases when you're assessing whether a claim is ambiguous or not is it impossible for the skilled person to know in advance whether or not something would be within the claims? And in this case, Justice McAfee answered that question. Yes, it is impossible. And so in this case, the disputed claim term that was subject to the ambiguity analysis was depletion layer and certain characteristics of that depletion layer. And the first thing to note is that depletion layer is a coined term. So it's not a term of the art. It's not a term that the experts were familiar with. It's a term that essentially the inventors made up to try to help explain what their invention is. And that's not a problem in and of itself. You're allowed to have coined terms in a patent claim. But if you do, you better make sure that you define them or explain them somewhere in the patent specification. And in this case, depletion layer was not defined anywhere in the patent specification. And there was otherwise no objective measure or test by which a skilled person could assess whether a metal powder particle had a depletion layer or not. So there was no objective anchor. And ultimately, this was determinative of the issue of claim ambiguity, and Justice McAfee found that all of the claims were invalid for being ambiguous. And one of the issues that AP&C ran into is with their expert evidence. And so they had presented multiple testifying experts who provided an opinion on overlapping issues. And the trial judge noted that when they were trying to assess whether a metal powder particle had a depletion layer or not, they all had proposed different theories, which were in some respects inconsistent with one another. So the trial judge asked himself, if AP&C's own experts are presenting inconsistent opinions on how to determine whether a particle has a depletion layer or not, how is a skilled person meant to do so? So this wasn't determinative of the issue, but I think it reinforced the trial judge's findings with respect to ambiguity. And if we go to the next slide, so for me, the key takeaways from this case are, number one, when you see a coined term, this should raise some, I guess, warning signs that if you're going to use a coined term, it needs to be defined or explained somewhere in the patent. Otherwise, you may run into an ambiguity issue. And the other key takeaway for me is the issue that I mentioned just a minute ago, is the importance of consistency in expert evidence. So if you're going to call multiple testifying experts who are going to provide opinions on similar or overlapping issues, you should try to ensure that their opinions are consistent, especially when claim ambiguity is a live issue. Okay, so that brings us to another topic that we wanted to discuss, which is parent company liability in patent cases. And this is really foreign parent company liability. And in 2024, the case that addressed this issue involved Angel Care and Munchkin. And so this was a Court of Appeal decision. It was an appeal of a decision that found Munchkin Inc., which is the US parent company, as well as Munchkin Canada, to be liable for infringing several Angel Care patents relating to diaper pails and cassettes. And the cassettes are the annular refill cartridges that house the plastic film, which work in conjunction with the diaper pails. And the appeal dealt with a number of issues that are typically addressed on such patent infringement appeals. They dealt with infringement issues generally. They dealt with patent validity issues. But one issue that was addressed that's not commonly opined on by the Court of Appeal is this foreign parent company liability issue. And under the Patent Act, there are a certain list of activities that are the exclusive domain of the patentee, such that if someone else engages in those activities without the patentee's permission, they could be held liable for infringement. So these activities are making, constructing, using, and selling the invention. And in this case, Munchkin argued that Munchkin US did not engage in any of these activities in Canada. So why should it be held liable for patent infringement in Canada? And the federal court and the Court of Appeal said, well, it's not that simple. Justice Locke of the Court of Appeal stated as follows: a person cannot avoid liability for infringement by setting itself up outside Canada and then making arrangements from there that result in infringement of a patent in Canada. And the Court of Appeal set out two questions that are relevant to this inquiry of liability. Number one, did the infringing activities take place in Canada? And in this case, they clearly had. Munchkin Canada used and sold the infringing products in Canada. The second question is, did the foreign entity, in this case, Munchkin US, have common cause with Munchkin Canada, or was it otherwise a party to the infringement? And this second question is really a factual inquiry that assesses the foreign company's involvement in the infringing activities. And at the trial level, there was quite a bit of evidence on this point. These are the points of evidence that were cited in the Court of Appeals decision. But essentially, Munchkin US was designing the products, making the products. Munchkin Canada had never had any designers in Canada at all. Munchkin US was also making all of the decisions with respect to how the products would be marketed and positioned, how the products would be sold. And so Munchkin Canada's role was really limited to storing the products, distributing the products, and selling them based on instructions from Munchkin US. And so given those factual circumstances, the Court of Appeal didn't see any reason to overturn the trial judge's decision that this US parent company was sufficiently involved to be held liable for infringement in Canada. And if we go to the next slide. So again, these are my key takeaways from this case are that generally affiliated companies are treated as separate legal entities. So a separate legal entity is not necessarily liable just because it is affiliated or related to a company. To be found liable for patent infringement in Canada, a foreign affiliated company must have either completed the infringing activities themselves, so made, constructed, used, or sold it themselves, or been so involved to be considered as having common cause. And I'm not sure there's any magic to the term common cause. As I said, it's a factual inquiry that considers how involved the US company or foreign company was in those infringing activities. And yeah, with that, I'll pass it back to Dan.
Thanks, Matt. So we have a patent case going to the Supreme Court of Canada this year. And the question you may be asking is, what is it all about? So the case relates to a longstanding prohibition in Canadian law, patent law, that you can't patent a method of medical treatment. This is considered a subject matter exclusion. Essentially, you can't patent a method of medical treatment because it's not part of the definition of invention in the Patent Act. And this goes all the way back to a Supreme Court decision from 1974 called Tennessee Eastman, which you'll see there on the slide, finding that methods of medical treatment are not within Section 2. They weren't contemplated as being part of the definition of invention. Now, an interesting part of the reasoning in Tennessee Eastman, when the court was doing its statutory interpretation in arriving at this conclusion is that they relied pretty heavily on an old provision of the Patent Act that now no longer exists. So the Patent Act used to essentially say that you can't patent a substance intended for food or medicine. You could only get a patent on the process for making it. So that played a heavy role in the court's interpretation in that case. But even though it was abolished, ultimately the principle remained. And if we go to the next slide, the Apotex and Wellcome Foundation, also known as the AZT case, is another Supreme Court case from 2002. By that time, the old prohibition that you can't get a product claim on food or medicine had already been abolished. But the court still confirmed that there is a prohibition on patenting methods of medical treatment. And the reasoning is essentially that method of medical treatment is a matter of professional skill. It's not something that would be related to commerce. So the court drew this distinction between claims that called on professional skill versus claims that are more accurately seen as directed to commercial offerings. Essentially, are you trying to sell pills, or are you telling doctors how to do their jobs, is the crux of what the Supreme Court thought the issue was. And in that case, the court held that a newly discovered use for a known compound to treat a particular disease is patentable subject matter. They thought that was more in the realm of protecting your ability to sell pills, not telling doctors how to do their jobs. What followed was a series of cases relating to patent claims on dosage regimes. And the question is a patent claim that sets out a dosage regime patentable, or is it a method of medical treatment? And if so, is it always a method of medical treatment, or only sometimes? And the cases essentially came down on sometimes, and they largely turned on whether the dose being claimed was kind of a fixed dosage schedule or a variable dosage schedule. A fixed dosage schedule wouldn't require a doctor, for example, to exercise any professional skill. All the doctor would do is prescribe the medication, and in the fixed dosage, you wouldn't have to figure anything out. But if it was variable, for example, if there's ranges within which the doctor would have to practice professional skill, that was considered to be unpatentable in that line of cases. In its 2024 Farmer Science decision, the Federal Court of Appeal clarified the law. Essentially, they found that this fixed versus variable question isn't a bright line test. It may be a proxy or a factor in some of these types of cases, but really the court thought that you need to focus back on the initial distinction that the court cited in the AZT case, which is, are we talking about professional skill, or are we talking about something that's more of a commercial offering? And the way the federal court prefers the question to be asked is this distinction between whether and how. So is the only question that the doctor has to answer whether to prescribe the medication, or is there going to be a further question that the doctor has to answer as to how to implement the dosage regime set out in the claim? And in this particular case, the court answered the question in favor of the patentee. They said, no, the only question was whether, and therefore the claim was a valid subject matter. And that's what the Supreme Court is going to be grappling with come later this year. Another interesting update in 2024, again, relating back to the question, how quickly can I get an injunction? Well, one of the things that has to be considered nowadays is summary proceedings. We have summary judgment, we have summary trial. Both of these are ways to get to judgment faster and more efficiently. Back in 2014, the Supreme Court called for a culture shift towards more efficient judicial processes in appropriate cases. And then we had the federal court adding the summary trial process to the rules and making that available. And so I think one of the important things to understand here is that there is a distinction between the two. Summary judgment is a motion that one party brings where they say, court, you can decide this issue just on this motion. You can decide the whole case on this motion because there's no genuine issue for trial. And that's a bit of a hard standard to meet. And that's where a summary trial comes into play. So the court can say, well, even if there is a genuine issue that would require hearing and sorting out evidentiary issues, for example, we can still resolve it by having a mini trial, otherwise known as a summary trial. But a bit of a roadblock has arisen relating to the burden of proof in the summary trial. Now, in regular trials, the burden of proof is pretty well settled. For the rights holder, you have to prove infringement. For the defendant, if there's a registered and subsisting IP right, you have to prove that it's invalid on a balance of probabilities. And if it's registered to an owner, you have to prove on a balance of probabilities that that person is not the owner. But the question arises, what if you're the party bringing the summary proceeding? That adds a layer of complexity to the issue of burden, and the court has struggled to deal with it. So we had a decision in 2021 saying, well, the onus is always on the party that brings the motion, even if the issue went to trial, the onus would be on the other party. So that was one early decision we had on summary trials. But in 2022, there was another case that considered the issue in more detail and found that the onus of proof should really be the same as it would be for a regular trial. If you're doing a summary trial, the burden of proof is the normal burden of proof that would always apply. And there were a number of cases that followed that line of reasoning, but later in 2022, we had the federal court decision in this mud engineering matter where the court went back to the first approach saying, well, actually, no, the correct approach is that the onus is always on the party bringing the motion. So the mud case was an ownership dispute, and the motion for summary trial was brought by the patentee. And ultimately, the court found that because the patentee brought the motion, they had to prove that they were the owner on a balance of probabilities. And the court ultimately dismissed the action, finding that they failed to meet that burden. Now, it seemed pretty clear from the court's reasoning, and the court actually specifically says that the burden of proof in a summary trial is determinative of the case. So that finding appeared to be essential, but it was contradicted, as I mentioned, by several other federal court decisions, which thought the burden actually was should just be the normal burden that would be applicable, which would mean that the plaintiff would not have had to prove ownership, only defended against the court finding that they were not the true owner, which the defendant would have to prove on a balance of probabilities. So at the federal court level, the defendant also failed to prove that it should rightfully own the patent. So as between these parties, the patent had no owner, and that was the final answer. The action was dismissed for because of the finding that the patentee didn't actually own the patent, but neither did the defendant. So there was some hope that the Federal Court of Appeal would untangle this issue of what's the burden in a summary trial. And that's where we ultimately ended up in this 2024 decision. But the majority of the Federal Court of Appeal declined to decide the issue of who has a burden in a summary trial. It agreed with the federal court on the result. So arguably, they implicitly found that the plaintiff did have some kind of a burden to prove ownership, but ultimately, it is not exactly clear why in the majority's reasoning. The dissent would have found that the federal court did not properly consider whether the defendant's failure to establish that it was the rightful owner should have been determinative in favor of the plaintiff on the issue. So overall, I think litigants are going to be thinking very carefully before initiating summary trial proceedings, depending on the types of issues involved, at least until this issue of the burden is resolved with more certainty one way or another. Certainly, in many cases, the party would not want to take on a burden of proof by bringing a summary trial motion that it otherwise wouldn't have in a normal trial. So even though there's been an uptick in summary proceedings, they've been very useful in getting quicker and more efficient results in recent years. There may still be an issue here that needs to be sorted out before they could be even more fully adopted. All right, I'll turn it over to Matt, who I believe has a couple of other quick points to mention, and then we'll answer a few questions.
Yeah, I see we have about 10 minutes left. So Matt will take us through those last two topics, which are a bit shorter. So now is the time. If you have questions, please put them in the Q&A function, and we'll either answer them at the end, or maybe I'll if we have any questions, I might interrupt Matt.
Okay, yeah, I'll try to be quick. So the next topic is artificial intelligence tools. And briefly, I'll just talk about some of the risks associated with using these AI tools that were brought to light in 2024 and maybe a little bit before 2024. So one of the risks in using AI tools is what's called AI hallucinations. And what AI hallucinations are is content that has been fabricated by AI in response to a request or prompt that is false or misleading, but presented as fact. And one of the most, I guess, highly publicized Canadian cases that addresses this issue in the litigation context is a BC case, Zhang v. Chen. And as you can see, this case was picked up by a number of news outlets, including CBC News. And essentially what happened in that case is one of the lawyers for the parties in this family law case had brought an application in the BC court, and in support of that application, they relied on several cases that did not exist. So this ultimately came to light before the court, and as a result, the lawyer who had relied on these AI hallucinated cases was found personally liable for some of the costs that the other side had to bear in identifying and addressing these false citations. And in 2024, we saw this same issue creep into the IP litigation context. There are at least two trademark opposition board decisions in 2024, which dealt with this very same issue. So these are the two cases listed here in the chart. And in both cases, the trademark opposition board noted that one of the parties had cited cases that did not exist and made a note of that in the case, and ultimately didn't rely on those cases. They disregarded them and any arguments that were supported by those cases. And in response to some of the issues that we're now seeing with the use of these AI tools in the litigation context, the federal court has released a practice notice. And the gist of this practice notice is that the federal court acknowledges that there are obvious benefits to using AI in the legal context, perhaps especially with respect to self-represented litigants, as these tools can synthesize large volumes of documents and potentially help them navigate the legal system. But at the same time, if we're going to use these tools, we have to approach them with extreme caution. And so one of the requirements that the federal court has put in their practice notice is that for any materials prepared for litigation and submitted to the court, if any portions of those include content that were created or generated by AI, then you have to make a declaration at the outset of your submissions identifying which paragraphs were created using AI. And so I'll stop there in the interest of time and move to the final topic, which is an update on costs, and in particular, the doubling effect of Rule 420. So there were a few cases in 2024 where we saw the federal court applying this Rule 420 to double the costs awarded from the date of a settlement offer moving forward. So just briefly, in Canada, the cost regime in litigation matters is generally loser pays a portion of the winner's legal fees and also 100% of their reasonable disbursements. And typically in the IP context, the largest portion of disbursements is expert fees. And there's two methods of calculating costs awards in Canada. There's the method of calculating costs under the tariff, and there's also the other method of applying a percentage to the actual costs that were incurred by the successful party. And the tariff calculation is more formulaic. It requires kind of a line-by-line analysis of the steps that were taken. Only some of those steps are subject to cost consequences. So the major downside of a cost award pursuant to the tariff is that it undercompensates the successful party when compared to the actual costs that they incur. So as a result, in recent years, the federal court has adopted this lump sum approach, which is in theory simpler. You just apply a percentage to the actual legal fees that were incurred by the successful party, and you go from there. And so generally as a starting point, the lump sum percentage amount is between 25 and 37%, I would say, at least in recent cases. And the judge has full discretion to move this percentage up and down, depending on a number of factors, including the complexity of the case, the conduct of the parties, etc. And so one of the primary driving forces for costs in Canada is to encourage settlement. And I think this is the main justification behind Rule 420, which can have a doubling effect on the cost award from the date of a settlement offer is made, if that offer meets certain conditions. And those are listed there. I'll just touch on them very briefly. So number one is that the terms of the offer that you make have to be more favorable than those obtained at trial. So if I'm a plaintiff patentee and I offer to settle the matter, the defendant pays me $1 million, but at trial, the judge awards me $100 million. Well, then the defendant probably should have accepted that offer, but I offered them terms more favorable than the outcome at trial. The other requirements are timing, has to be 14 days before trial and not withdrawn at the start of trial, has to put an end to the litigation. And the last one is there must be an element of compromise. And as I said, there were a few cases that applied this doubling rule in the federal court context in 2024. This is just one example where the cost award was doubled from 33 to 66% from the date of this Rule 420 settlement offer. And in this case, the key issue was whether there was an element of compromise. So you can see Tekna's offer at the bottom of the slide. Essentially what they offered was each party discontinue their claims, counterclaims, walk away, no money changes hands. Each party handles their own costs. And in AP&C's view, there was no element of compromise here. There was no financial compensation to recognize the risk that Tekna could be found to infringe. So in their view, there was no element of compromise and the Rule 420 shouldn't apply. The trial judge disagreed. He actually suggested that there were two elements of compromise. One was the agreement not to pursue costs, and the other was the withdrawal of Tekna's invalidity claim. So even though AP&C couldn't enforce their patent against Tekna, there's still value in having a valid patent, which you could potentially enforce against another party. And so my key takeaways from this case are that, number one, Rule 420 offers are a pretty impactful rule in terms of the amount of costs that you could be awarded. So it's something to consider as part of any litigation strategy. Number two, the element of compromise requirement seems to be a pretty low bar and can be met without offering any financial compensation to the other side whatsoever. And finally, that the doubling effect of Rule 420 applies to both costs determined under the tariff, and as we've seen in 3 cases now in 2024, also the lump sum percentage. So just briefly on that last point, AP&C argued that if you apply the doubling effect to a lump sum percentage of 40 or 35%, it could be seen as punitive, such that costs are at 80% or potentially 100%, depending on the base percentage that you're working from. And they said that such awards are limited to punishing the defendant. And Justice McAfee said, no, costs are in the discretion of the court. If that is the case, then the court could simply just not order doubling of costs. So there's always the discretion that's retained by the court in cost awards.
All right. Thanks, Matt. Thanks, Dan. We only have 2 minutes left. I don't see any questions at the moment, but if you have one, now is the time. If not, you'll receive the articles on the website. As I said, there are other year-end reviews articles on the website that you might be interested in. You'll, I think, you'll also receive a copy of the slides. So if you have questions afterwards, you have our contact information. So feel free to reach out and ask questions. And lastly, as we end the webinar, you'll be there's a survey that will pop up automatically. So if you have a minute, that will be appreciated if you could provide feedback to the team for next year. And on that, still no questions. So I think we'll say thank you for attending, and we'll see you next year.